Senator Markley.
Thank you, Madam President. The support last year was broad but not unanimous, and that was because I cast a rather lonely vote against it. And I did that last year, I guess I would say on instinct as much as anything else. And I have, because of that, been pushed on it and challenged on it. And the time between now and then, I've rather been forced to look into it. And I feel like the longer I've looked at it, the more uncomfortable I am with the bill that's before us. So I rise again in opposition to this bill, and I will comment, I will explain my opposition, not at, I hope, tedious length, but enough that you understand what's going on. Is there a problem with sexual assault on campus? I think that's established beyond question. And I think there's a problem with sexual behavior on campus generally, which is a result of a kind of well, one might say a hookup culture, which has developed over the years, that I think has left young people feeling confused about what they're doing, frequently hurt by the relationships that they enter into, and I think ultimately rather empty and dissatisfied with the experience that they're having. What might be termed romantic experiences, but more strictly are sexual, and I think too often are strictly sexual experiences. Romance and love are fundamental human needs and desires, and I think they're lost in a world that accepts a very casual relationship that's developed over the years, and especially on our college campuses. On our college campuses and among our youth, I think we're told that sexual behavior on one hand is no big deal, that the act of sex is not necessarily supposed to be something of profound significance. And yet at the same time, we're told that in a sense of our own identities, it's central to our identity. And I feel like there's a disconnect between those two lessons. And I think that it's not surprising that people are confused when this relationship ends up being so superficial. And it's a different experience in that way, I believe, for men and women, but I think it's one that leaves both of them dissatisfied and pained because of the hunger that we have for attachment. And part of attachment is physical intimacy. And the lack of attachment and the lack of commitment leads to bad behavior. And that bad behavior frequently slides on over into what I think properly can be termed sexual assault. And I understand where Senator Flexer comes from on this, and I sympathize with what she's trying to accomplish. I think that too much of what happens has entered into a gray area, which this bill attempts to define. Let me say also in passing on this that the unspoken element behind a great deal of this bad behavior, in my opinion, is drinking, and drinking to excess, which has become a very common thing on our college campuses. Washington Post did a survey concerning sexual assault in 2014 that reported that 60...
I'm sorry, Senator Markley.
Yes.
I'm asking if, please, nobody can hear what Senator Markley is saying. Can we please keep our voices lower? Thank you, Senator Markley.
Thank you very much, Madam President. The Washington Post reported that 62% of the women who said they had been sexually assaulted had been drinking. And I suspect the number of the men who were involved in those behaviors was probably at least that high, if not higher. 77% of the students, of all students who responded in this survey, said that limiting alcohol on our campuses would be a positive thing in terms of bringing sexual assault under control. I was tempted to address that question directly. I have an amendment that has been sitting on my desk that I never signed and filed, which would prohibit drinking on our state universities. I felt in the end it was perhaps draconian. It was certainly unprepared. It's something that I think might be worth our consideration, given that we agree that this problem is as bad as on campuses as Senator Flexer indicates. And if we agree about that, I think that we can look at it from two ends. One is the end of dealing with the aftermath of this unfortunate behavior, but the other is to try to change the circumstances on our campuses that are contributing to this behavior. And there's no question in my mind, and I think you would find there's no question in the mind of college administrators, if they speak honestly about it, that the prevalence of drinking on our campuses is a problem. I'd add that I don't believe that the drinking in and of itself is something that we have to preserve on campuses. Some very fine colleges and universities have no drinking, not just the ones that you'd guess, but Wheaton College and some of the state universities in the Midwest have a zero tolerance policy for alcohol. People still go there and learn and play football and do everything else, and I can't help but think that they benefit from that restriction. Instead of approaching it that way, which is not what the bill is about, we have a bill now that aims at how we handle the cases which have already occurred. And obviously the point is not to have them occur. Senator Flexer has proposed something which sets up a kind of a schedule for these kinds of relationships. I'm afraid that in doing this, it effectively criminalizes many behaviors that many of us would consider entirely normal, because the affirmative consent policy asks that consent be asked at each point in a romantic experience. I think that if I said, for instance, that if a woman who had not seen her boyfriend for a long time came up and immediately on seeing him kissed him on the lips without asking permission, that in itself might be termed misbehavior. That sounds like a ridiculous example, but I will mention a case that took place in Connecticut in which an unwanted kiss was in fact the basis for a charge of sexual misbehavior. It also holds that passivity in the course of a romantic interlude is not meant to be an acceptance. And that means that insofar as two people are cooperating in this experience, let's say a fault upon fault is laid upon the person who could be charged with committing this sexual misbehavior as the relationship progresses. I feel like almost any of us, if we think about our own experience in life, would say that we have done things and even continue to do things under this policy which do not correspond to affirmative consent. And to change that behavior is to ask a change in human behavior, which I think is unrealistic for us to ask for and unwise in terms of social engineering. It's beyond our capacity. I would also say, in a sense that I almost find entertaining, I heard for many years the mantra of getting government out of our bedrooms. And I feel like I've never seen a policy which more directly inserts government exactly into the bedroom, even into the living room, into the front porch, into the back seat of the car, into every place where we think of having intimate experiences with people. The good news, we might say, is that this policy doesn't apply to us. It doesn't apply to us or anyone in this building except maybe the college interns. That was really the reason I voted against it last year, if I had to say that there was one reason: the unequal application of this law. It still doesn't make sense to me to say that we're going to make laws for the sexual behavior of college students at colleges both public and private, and nobody else. So two students who happen to live in Waterbury and go to Naugatuck Valley Technical College are under one set of rules, but two people of the same age that don't happen to be at the same school are not covered by the same law. It seems like an unequal application that simply doesn't make sense to me and is indefensible to my mind. I'd also question, I believe that the colleges themselves have the ability, I know the colleges themselves have the ability to put these rules into place. They have been doing so under their own initiative. And I have no objection to the colleges making rules for their own students. I don't understand why we have to force them to make those rules. Senator Flexner might say this bill gives them latitude to use the rules that they have in place. But the bill is rather specific in saying those rules effectively have to be the same rule as the one that we're laying out for them, or they're not applicable. I have a further concern in this bill about procedure. The bill puts into law the powers of a campus tribunal, but it doesn't specify the way that such a tribunal functions, except in a very cursory way. The tribunals, as they exist, lack many of the things that we would consider essential legal protections in any kind of a case going forward. I would say, above all, these tribunals work not on the basis of reasonable doubt or even a lower standard, which is clear and convincing evidence, but on preponderance of evidence, which is the lowest standard that legally is made for judgment. To say everything weighed, if 51% is on one side, then the case is proven. That is considered adequate only for civil cases, only for cases which involve monetary damages. The Supreme Court back in 1982 ruled that for any case which required or which involved the deprivation of liberty or in which stigma was involved, that clear and convincing evidence was the lowest standard applicable. And I think nothing could be more stigmatizing than to be found guilty of this kind of sexual misbehavior. Something that can result in your expulsion from school, a very public thing. You're being forbidden from being on campus. Something that ends up as part of a permanent record, something you will have to explain for the rest of your life. And in all these cases, I believe that the burden of proof falls on the accused to prove that consent was obtained, and not just once, but repeatedly throughout the process. A burden of proof in a situation which is almost by definition a private situation, in which there are unlikely to be witnesses, there are unlikely to be recorded evidence. It can't help but end up being a case of he said and she said. How do we expect an accused person to clear himself under circumstances like this? Furthermore, in these tribunals, there's no guarantee of an access to counsel, there's not a protection against self-incrimination, and there's no assurance that a single person might not act in multiple roles. An administrator who both gathers the evidence, makes the case, presents the, oversees the tribunal, and passes judgment. Possibly all four roles, possibly a couple of those roles, but not the division of role that we expect in our court system. I'm not alone in my concern about this lack of protection for the legal process. Groups that are not allies of mine normally, leaders in the ACLU, the large cohort of people in the American Association of University Professors, 70 members of the American Law Institute have voiced their concerns about the need for proper protection of those accused before tribunals on campus for sexual misconduct. Attorney Naomi Schatz, a liberal attorney writing in the Huffington Post, wrote, "We as feminists are failing if we make our victories dependent on eschewing the fundamental rights and principles our legal system was founded on: fairness, due process, a presumption of innocence, in order to obtain findings of guilt in sexual assault cases without regard to the facts of individual cases. A system that is as unfair to accused students as the one currently employed by U.S. colleges and universities lacks legitimacy. And the more people learn about the fundamental unfairness of these systems, the more skeptical they will become of accounts of campus sexual assault and any resulting actions by the schools." Those are theoretical objections, but the fallout from this has been real. there have been many, many lawsuits already filed against colleges and universities as a reaction to the actions that they have taken through these procedures concerning sexual assault. And we've had several high-profile cases of this right here in Connecticut. I'll mention just one of them at Wesleyan University, which took place just a couple of years ago. A student who had an unblemished record, disciplinary record on campus, a 3.9 grade point average, a member of student government, texting, this was back in December of 2013, with a friend of long establishment, made, let's say, improper advances to her by text, while he himself was admittedly drunk. He saw her the next day and apologized for this, and reportedly she accepted his apology. 4 months later, in April of 2014, at a time that his vote on student government was considered important for a particular issue that was being debated, the student who had been the recipient of these improper texts went to the dean of students and complained about sexual harassment. The student involved was given a no-contact order by the dean of students, and in fact was then forbidden from participating in the vote on student government, which was passed in his absence, contrary to his position. In May of that year, and this was May of his senior year, another student accused this young man of kissing her without consent in 2010 during their freshman year, in fact, during the first week of his freshman year at college. They subsequently had a relationship themselves. In fact, she went to a formal dance with him some months after the alleged incident. But that May, in a disciplinary hearing, as a result of these two incidents, one a case of drunken texting, and the other the case of 4-year-old incidents of unpermitted kissing, the student was in fact ejected from Wesleyan, refused graduation, and as a result of that blemish on his record, fired that summer from a job he had in a congressional office. That is, let's say, that is a very serious consequence. And whether the student was deserving of that consequence or not, let's say I will leave aside for the moment, but to suffer that consequence without going through a formal procedure, having been asked to testify about events without knowing what the charges against him were, having been denied the opportunity for legal counsel at the hearing, seems to me a real case of human misfortune by a system that we are now going to put into statute. It's also a case of selective enforcement. There's an argument to be made that in this instance, because of what was going on in student government, a decision was made to bring action against a student to prevent him from participating. And selective enforcement, again, is a very dangerous thing for us to encourage in any way. I feel on these campuses that we have condoned and accepted a kind of a bad behavior. And then we have destroyed lives when that bad behavior has led to bad consequences. I think we've done that by putting unworkable standards into place that are undertaken by improper means. And I will offer